The reason I really wanted to focus on this tonight is that it's easy to focus on the really big things in the United States Supreme Court, the abortion issues that come to the court. But this is the kind of day-to-day way in which the United States Supreme Court can have this country take a turn that most people won't notice.
Yeah, people don't know what the Chevron doctrine is. You can stop somebody on the street and say, hey, what's the Chevron doctrine? And unless they're a very particular kind of lawyer, they won't know. But what it is the doctrine that lets America's regulatory agencies make the decisions where they have expertise. And it's really important when you're up against big industries that have a lot of experts to have experts against them who can call BS on them, who can call their bluffs, who understand the complexities and don't get fooled. And what these industries want to do is they want to shut down the regulatory piece of that and move so that they can make their arguments to courts, which are not expert, which are much more easily fooled, and which, if you pick the right judge, are on the side of the big industries now anyway, after all of the Federalist Society's work packing various courts.
And one of the things we've grown accustomed to hearing from the Republican judges on the Supreme Court is that Congress hasn't specifically authorized X or Y. Congress has very specifically authorized what is at issue here.
Yeah, there is so much of the argument against the Chevron doctrine and against administrative regulations that is just complete hogwash. For instance, they say that it's completely unaccountable and therefore not part of our proper separation of powers. And yet the piece you just read from Justice Kavanaugh was him saying, actually, it changes every 4 to 8 years, right? Responsive to the public. And Congress, our appropriations committees go over these agencies every single year. And we've got the Congressional Review Act to respond immediately if they get out of line. So they're super accountable. They're very responsive to the political pressures that are around them, but they do it from a position of honesty and integrity and expertise. And that is what the polluting industries can't bear.
It sounded like the Republican judges on the court were ready to get rid of this principle completely.
Well, it'll be interesting because they shot a major torpedo into the American regulatory system back in the West Virginia versus EPA case by creating something called the major questions doctrine. Remember, too big to fail? This is too big to regulate. That would have to go back to Congress. So this Chevron doctrine overlays with the major questions doctrine, and it wouldn't surprise me if they were a little bit chastened and hung back a little bit on taking too big of a bite out of the Chevron doctrine, A, because it's nonsense, and B, because they can do so much of the damage that their backers have put them out of the court to do using the major questions doctrine. They don't need to undo Chevron to do a lot of damage to the American regulatory system.